A physician had hospital privileges at the local hospital where she did her surgeries and she could admit her patients. And complaints arose, and the hospital got up a peer review committee which recommended that her hospital privileges be terminated, and they were terminated. Now, she got most of her revenue from this kind of work, so she brought a Title VII case claiming sex discrimination, religion, and ethnicity discrimination. But the question is, was she an employee for purposes of Title VII? And the Seventh Circuit applied a typical five-factor test, and I'm not going to go through all those factors because the main factor is control. She brought her own staff into the operating room. She paid them. The hospital didn't pay her. She had total control over how she did her surgeries. So the hospital really didn't have control over her time and work except for scheduling the operating room. And she came up with this theory that because the hospital had a peer review committee that looked at what she had done, that was the kind of control that made her an employee. And the Seventh Circuit says, no, this is after the fact, looking at what she had already done to see whether it was up to snuff. That's not the kind of control that makes her an employee for purposes of Title VII. I will see you next week.